Breaking news! Obama did a treason! Now will you all please stop talking about the Epstein files? On July 18th, Director of National Intelligence Tulsi Gabbard, who recently invoked Trump's wrath for disagreeing with his alternative facts about Iran, found a way to wrest control of the media cycle and perhaps prove her loyalty once again. Gabbard held a press conference to announce her office's sudden findings that during the 2016 election, the Obama administration's investigation into Russian interference was actually treason.
The expressed intent and what followed afterward can only be described as a years-long coup and a treasonous conspiracy.
In the press release that followed, the smoking gun evidence was the fact that the Obama administration acknowledged Russia tried to influence the 2016 presidential election.
In this system, there is to be a peaceful transition of power. So, yes, this is a treasonous conspiracy that subverts the will of the American people.
But MAGA loves a good conspiracy theory. So Tulsi and Trump are swapping out the Epstein conspiracy for the Russia election interference hoax, the Obama connection. After the bizarre press conference, Trump then posted AI slop of Obama getting arrested in the White House, bizarrely set to the Village People's YMCA, which I'm going to replace with whatever I find at the top of North Korea's charts on Spotify. Enjoy. Now, actually charging President Obama with treason would be even more absurd and ridiculous than the press conference or that video, because treason is a very specific, very serious, and very misunderstood crime. No American has been convicted of treason since 1949. But from a lawyer's perspective, absurd and ridiculous is the legal theme of the Trump administration. So Obama needs to lawyer up now. Let's talk about why. And don't worry, we are not going to forget about the pedophile-shaped elephant in the room. In 2016, an age ago, back when most of us thought it was darkly hilarious that someone as ridiculous as Trump was running for president, there were credible reports from intelligence agencies that Vladimir Putin intended to wage a sophisticated cyber warfare campaign against the United States, specifically to hack the 2016 election into the outcome that would most benefit Russia. US intelligence agencies contemplated several dire scenarios, including the possibility of Russia directly hacking into US election infrastructure like polling stations. And these fears were well-founded. At this point, Russia had spent years perfecting their cyber warfare toolkit, including the first confirmed cyber attack on a power grid in 2015, which led to outages for over 230,000 Ukrainians. The intelligence community ultimately determined that direct attacks on US election infrastructure were unlikely to be successful in any meaningful way, but they were blindsided by the other cyber weapon Putin developed during his invasion of Ukraine: social chaos fueled by viral social media. The 2014 invasion, to be clear. Now, Ukrainians were mostly immune to these psychological weapons, as the vast majority of Ukrainians despised anything that tasted of benefiting Russia. But here in America, we don't wash our hands before or after gorging on partisan bullshit. And so in 2016, at Putin's direction, Russia fired their cyber weapons onto the US in a highly coordinated, sophisticated, and well-funded campaign of disinformation and social media outrage. This was done with the explicit documented goal to influence the election in Donald Trump's favor, and to spread doubt about the integrity of the US election system. And while the extent of Russia's impact remains uncertain and debated, it's quite plausible that this was the cyber warfare version of the Ebola virus. If you're a fruit bat, Ebola gives you a tummy ache. Primate? It liquefies your insides. Now, at the same time that Russian government-produced outrage media was going viral in the US, one of Putin's elite hacker groups, known in the intelligence community as Fancy Bear, you can't make this up, succeeded in a direct attack on the Democratic National Committee's servers. Fancy Bear, under Putin's command, then released a trove of embarrassing emails to the public via DC Leaks and WikiLeaks. This sent Putin's active cyber warfare weapons on social media into overdrive, reaching new heights of virality and appeal. All the while, Russia operatives and spies like Marina Butina and Alexander Torshin wormed their ways into the highest echelons of the GOP and MAGA movement with the same mission: get Trump elected. But how much did Trump himself participate in, endorse, or collude with Russia in these activities? Well, renowned Russian policy expert Andrew S. Weiss and artist Brian Box Brown made a graphic novel about it that illustrates the most salient facts. Candidate Trump's behavior created a counterintelligence nightmare for Obama's national security team. Trump held secret talks during the campaign about a big real estate deal in Russia and lied about it. He repeated Kremlin talking points on issues like Putin, Ukraine, NATO, and sanctions. According to investigators, Trump's campaign had 272 contacts and 38 meetings with Russian government-tied representatives and cutouts. He reveled in Russian-backed disinformation and hacking operations against the DNC. And despite extensive press reporting on Russian interference in the election, the Kremlin formally denied any involvement. Yet by September 2016, Putin was cracking jokes in public about the hacks. You be the judge. But as former CIA Director Michael Hayden put it, Russia election meddling was the most successful covert operation in history. And these are the facts, as established by Special Counsel Robert Mueller, who was appointed to lead an independent investigation into what happened. These facts were confirmed by a bipartisan Senate committee that even included then-Senator, now Secretary of State and flaccid micropenis, Marco Rubio. Of course, Trump has said he didn't bother reading the Senate's report. When asked about the report, he said, "I don't know anything about it. I didn't read it. It's all a hoax." Over the years, the Russian election interference hoax conspiracy theory has become MAGA doctrine. In 2020, the Republicans in the House Permanent Select Committee on Intelligence conducted their own investigation, nitpicking the intelligence community's findings. The committee issued a document titled Report on the Manufactured Russia Hoax. Their report largely confirmed the key facts of the Senate report and the Mueller report, but they disagreed on the extent to which Trump was involved and the extent to which Putin was motivated by a Trump victory. The matter was settled. Reasonable minds can disagree. But then, on July 25, 2025, Tulsi Gabbard, the controversial head of the Office of the Department of National Intelligence, or ODNI, released a previously classified version of the Republican House Committee's report and accused President Obama and several members of his administration of engaging in a treasonous conspiracy, claiming that their goal was to subvert the will of the American people and enact what was essentially a years-long coup with the objective of trying to usurp the president from fulfilling the mandate bestowed upon him by the American people. But the classified version of the Republican House Committee's report that she released doesn't support those accusations. The report admits that, quote, the bulk of the intelligence community's judgments on Russia's election operations were sound and employed proper analytic tradecraft. So, off the bat, the House report agrees that the intelligence community's assessments were mostly correct. The House committee agreed that Russia engaged in cyber warfare to influence the 2016 elections, that Russia was responsible for the hack on the DNC emails, and that Russia sought to undermine faith in US elections. What the Republicans took issue with was the idea that Putin did this in order to help Trump. They claimed that the intelligence community's assessment was based on insufficient data, ignored contrary information, and wrongly relied on the largely discredited Steele dossier. So, along with the 2020 House report, Tulsi Gabbard's politically captured ODNI released a brief, haphazard-looking memo and a public statement with 6 claims that build their foundation for their treason accusations against President Obama. Let's break these claims down. First, in the months leading up to the November 2016 election, the intelligence community consistently assessed that Russia is probably not trying to influence the election by using cyber means. This is untrue. What the intelligence community actually said is that Russia was not trying to hack election infrastructure. That's different from saying that the Russians weren't trying to influence US elections at all. Even the Republican House Committee acknowledged that the Russians did try to influence the election by using social media and hacking and the release of stolen DNC emails. Second, ODNI argued that on December 7, 2016, after the election, talking points were prepared for Director of National Intelligence James Clapper, stating foreign adversaries did not use cyber attacks on election infrastructure to alter the US presidential election outcome. No one disputes this. Neither Obama, nor the bipartisan Senate report, nor the intelligence community assessment, nor the Mueller report ever claimed that Russia hacked election infrastructure. The investigations on this topic focused on whether Russia attempted to influence the election by using social media and by hacking and releasing damaging DNC emails. And all the reputable investigations concluded that Russia did that. So Clapper's talking point about hacking election infrastructure doesn't show that he or Obama were lying when they later claimed that Russia tried to influence the election in other ways. Next, ODNI claimed that on December 9, 2016, President Obama's White House gathered top National Security Council principals for a meeting that included James Clapper, John Brennan, Susan Rice, John Kerry, Loretta Lynch, Andrew McCabe, and others to discuss Russia. And after the meeting, DNI Clapper's executive assistant sent an email to IC leaders tasking them with creating a new IC assessment per the president's request that details the tools Moscow used and actions it took to influence the 2016 election. It went on to say ODNI will lead this effort with participation from CIA, FBI, NSA, and DHS. This is also true and undisputed, and this is how government works. The president holds meetings and tasks agencies with conducting investigations and assessments. The president gets to choose priorities, and the executive agencies try to deliver on them. This was a fast turnaround assignment, given in early December and due in early January, but that fast turnaround was necessary because Trump was about to take office, and the Obama administration guessed, accurately, that Trump wasn't exactly going to be impartial about fact-finding. Next, ODNI alleged that Obama officials leaked false statements to media outlets, including the Washington Post, claiming Russia has attempted through cyber means to interfere in, if not actively influence, the outcome of an election. But this isn't a false statement, nor is it a leak. Every credible investigation concluded the same thing. Even the House Republican Committee had to agree that Russia tried, via cyber means, to influence the election. Even they conceded that the bulk of the intelligence community's judgments on Russia's election operations were sound and employed proper analytic tradecraft. Their dispute was not whether Russia tried to influence the election, but whether Russia did that explicitly in order to help Trump win. Finally, ODNI claimed that on January 6, 2017, a new intelligence community assessment was released that directly contradicted the IC assessments that were made throughout the previous 6 months. This is also false because, again, the intelligence community assessment didn't contradict prior statements regarding Russia's intentions to and ability to hack election infrastructure. It addressed a totally different question. Did Russia try to influence the election? And, like the Senate and the independent Mueller investigation, the intelligence community concluded that Russia did try to influence the election using the arsenal of cyber weapons and tactics they developed and honed in their war against Ukraine. So it's pretty disingenuous to claim that just because Russia didn't hack voting machines directly, it didn't do anything to try and influence the 2016 election. Curiously absent from these reports and the House committee findings that attempted to distance Trump from Putin's motivations is the fact that on the day after Trump's election, Russian lawmakers broke out a bunch of champagne. Still, according to Tulsi Gabbard, Obama's actions amount to a treasonous conspiracy, and everyone involved, quote, must be investigated and prosecuted to the fullest extent of the law. So she referred the matter to the Department of Justice, which immediately launched a so-called strike force to, quote, assess evidence publicized by ODNI. Pam Bondi promised to leave no stone unturned to deliver justice. I wonder if she'll read the Senate report. In fact, there's a lot of things that Pam Bondi allegedly has on her desk that need addressing. And if Pam Bondi truly wants to leave no stone unturned to deliver justice, she'll read the Senate report. And hopefully do a smidge of legal research, even though what she'll find is really disappointing. That's because treason is an extraordinary charge, by design. It's difficult to prove and rarely prosecuted. America's most prolific treason doers are the Founding Fathers themselves, at least in the eyes of the British courts, which is what we base our own legal system off, by the way. But central to the American legal experiment was the concept that the government was based on the consent of the governed, not divine rule. So in order to have a democracy, citizens had to be empowered to debate and push back against their own government. As Justice Robert Jackson said in Kramer v. United States, the basic law of treason in this country was framed by men who, as we have seen, were taught by experience and by history to fear abuse of the treason charge almost as much as they feared treason itself. In fact, the founders were so concerned about the over-prosecution of treason that they even included the definition of treason in the Constitution. Quote, treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. If the Trump administration were to actually try to pursue treason charges against Obama and his associates, the first prosecutorial question is, were they trying to levy war against the United States? That would be a very tough argument because the Supreme Court has made it very difficult to demonstrate that someone has levied war against the United States. The most famous case on this topic relates to America's ambitious, anti-slavery, arguably feminist, act fast, think later, original gangsta Aaron Burr. Yeah, that's not the real Aaron Burr. Not long after he turned Alexander, I think president should rule for life Hamilton into a Facebook post, Burr went on to lead a conspiracy to create an independent nation in the American Southwest. Burr and his comrades assembled a private militia and planned to seize enough land to start a new country. His co-conspirators, Bowman and Swartwout, were first to go to trial on treason charges, and their cases, ex parte Bowman and ex parte Swartwout, ended up before Chief Justice John Marshall in the Supreme Court. And even then, the Supreme Court dismissed the treason charges, holding that the alleged conduct did not constitute levying war against the United States within the meaning of the treason clause of the Constitution. Chief Justice Marshall found that it was not enough to conspire against the country by recruiting troops, procuring maps, and drawing up plans. Conspiring to levy war was distinct from actually levying war. A person could only be convicted of treason for levying war if there was an actual assemblage of men for the purpose of executing a treasonable design. Burr then got his treason charges dismissed under the same theory. So if drawing up maps and recruiting troops isn't sufficient for a treason charge, the allegations ODNI has leveled against the Obama administration definitely wouldn't cut it. The ODNI's public statements and the documents the agency released essentially accused the Obama administration of misleading the American public about Russia's influence in the 2016 elections. That's not exactly an act of war, and it's definitely not an actual assemblage of men for the purpose of executing a treasonable design. The second potential path to a treason conviction is if anyone in the Obama administration gave aid and comfort to the enemies of the United States. This, again, would be difficult to argue. Not that some poor attorney at DOJ won't be tasked with trying. First, what enemies of the United States did Obama give aid and comfort to? The Russians? The intelligence community report actually clearly identifies the Russians as enemies of the United States, and Obama himself told the Russians to cut it out regarding election hacking.
In early September, when I saw President Putin in China and tell him to cut it out, there were going to be some serious consequences if he didn't.
So it's unlikely that anyone could argue that Obama was giving Putin aid or comfort. Or maybe the enemy the Trump administration would be referring to is the Democratic Party itself, since he's previously thrown around the accusation that Democrats are the enemy from within. Either way, this is unlikely to stand up in court. But let's say, for the sake of argument, that the Trump administration could identify an enemy that the Obama administration had assisted. Trump would still have to prove that Obama or his administration gave aid and comfort to that enemy. The standard for that is actually quite high. In the landmark Supreme Court case Kramer v. United States, Kramer was a naturalized American citizen born in Germany and charged with treason for allegedly helping German soldiers sneak into the United States during World War II to launch attacks on behalf of the German government. Once again, the court dismissed the treason charges against Kramer on the grounds that what he did, having some drinks and casual treasonous talk with an acquaintance who was secretly conspiring against the US government, was not legally sufficient to be considered aid and comfort. As Justice Robert Jackson explained, a citizen intellectually or emotionally may favor the enemy and harbor sympathies or convictions disloyal to this country's policy or interest, but so long as he commits no act of aid or comfort to the enemy, there is no treason. On the other hand, a citizen may take actions which do aid and comfort the enemy, making a speech critical of the government or opposing its measures, profiteering, striking in defense plants or essential work, and the 100 other things which impair our cohesion and diminish our strength. But if there is no adherence to the enemy in this, if there is no intent to betray, there is no treason. In summary, the Constitution requires both concrete action and an intent to betray the nation before a citizen can be convicted of treason. Expressing traitorous thoughts or intentions alone isn't enough. So even assuming that by promoting the Russian election influence idea, the Obama administration did somehow aid some enemy of the United States, the Trump administration would still have to prove that Obama and his team promoted that idea with the express intent to help that enemy. That's not supported in any of the documents Tulsi and ODNI released. Even Trump's usual lickspittles know these charges just won't hold up. In a recent conversation between Senator Ted Cruz and Laura Ingraham on Fox News, both admitted that Trump wouldn't actually be able to charge Obama with treason.
He's not going to be prosecuted for treason. But that's not going to happen.
He's not going to be prosecuted in all likelihood for treason.
But come on, we know the point isn't the actual charges. The point here is to shift attention from...
You might have noticed that we're producing way more content than ever before. That's because the law is now seemingly in the news almost every day, and it can make producing videos like this one increasingly challenging. But we just completed a full video about one of the craziest lawyers gone wild true crime stories that we've ever seen. It follows DC's golden boy attorney Tom Goldstein, who I technically used to work for, and his insane self-destruction from high-stakes poker with billionaires, secret girlfriends, robbing clients, tax evasion, and the Supreme Court. But because it's too hot for YouTube, the only way to see it is by signing up for today's sponsor, Nebula. You can watch all of our videos on Nebula ad-free without sponsorship messages like this one, and early because our videos always go up on Nebula first. Plus, every video we upload to Nebula this year is an extended cut featuring additional analysis and commentary that you can't get on YouTube. And signing up for Nebula is also an excellent way to support this channel and its mission to demystify the legal miasma that we live in. And people often ask if it helps this channel more to watch it on YouTube or Nebula, and the answer is emphatically Nebula. The watch time payouts are bigger, and since my creator friends and I created Nebula ourselves, we don't have to worry about capricious demonetization standards, which have been really frustrating on this year. For example, our recent video on the Diddy trial was age-gated because it showed security footage that was not exactly savory, and one video was demonetized because it showed a single image of the World Trade Center on 9/11. Now that was eventually taken care of, but we lost a huge amount of revenue because of YouTube's mistake. But all this is why Nebula is a better experience for the creator, and it's also a better experience for the viewer and legal eaglets like you. So if you'd like to sign up and get tons of exclusive content on Nebula only, you can get 40% off your annual subscription, a Year the Best content for just $36, or you can even gift that to a friend in a Nebula gift card. Or you can check out the lifetime subscription, where for $300 you can get access to Nebula forever. But either way, you can click on the link below. So sign up for Nebula, or I'll see you in court.
Just for the sake of argument, let's imagine that the Trump administration files criminal treason charges against former President Obama. How would that work exactly? Obama has never levied war against America or given foreign aid to an enemy, period. But let's pretend there is a case. How would it play out? A president can't just order someone's arrest. There has to be an investigation to get some evidence, and a prosecutor has to take it to a grand jury for indictment. That's kind of how the rule of law works at its most foundational constitutional level.
An explosive whistleblower report claims that the Justice Department is asking government lawyers to lie to the courts.
So I've come forward because the Trump administration has put civil servants in this impossible position of fealty to the president and the agenda, or fealty to uphold the Constitution and to uphold the rule of law. Ultimately, I didn't sign up till Iowa court.
That was whistleblower Erez Ruveni, who alleged that DOJ senior officials, including Emil Bove, who, as Liz Dye recently explained, has been nominated to serve as a federal appellate judge, urged DOJ prosecutors to submit misleading information to courts and defy federal court rulings.
Bove says, and if some court were to issue some order that prevents that from happening, we would have to consider telling that court, quote, fuck you.
The conditions Ruveni described led to a mass exodus of DOJ lawyers who refused to violate their duties as officers of the court. So using Bondi's new DOJ playbook, let's imagine how the Justice Department could bring a treason case against Obama. The Attorney General could take the conservative route and appoint a special counsel like Robert Mueller or Jack Smith to investigate and issue recommendations. But special counsels move slowly and run exhaustive investigations. And Republicans have claimed that the special counsel statute is unconstitutional anyway, so this may not be Bondi's preferred route. Instead, she could pick a loyal DOJ attorney. Let's call him Ed. And Ed passes the most basic requirements of having a law degree and passing the bar exam. So Ed with a law degree can take this case straight to a grand jury. Before anything hits a courtroom, FBI agents would need to open a formal investigation, gather evidence, and build a legal theory more substantial than I saw it on Truth Social. Ed with the law degree would then take the case to a federal grand jury. A federal grand jury is usually 16 to 23 ordinary citizens chosen at random from voter rolls. Grand juries are sworn to secrecy, and their deliberations are strictly protected. Grand juries don't determine guilt or innocence. Their job is to decide whether there's probable cause to believe a crime was committed. The grand jury process is one-sided by design. The defense can't present evidence, most rules of evidence don't even apply, and the standard is just probable cause instead of proof beyond a reasonable doubt. Prosecutors almost always get their indictments, hence the saying that a good prosecutor could indict a ham sandwich. Seriously though, prosecutors usually get indictments because they have evidence that someone committed a crime, and it's deeply professionally embarrassing for a grand jury to say no. But lately, some federal prosecutors aren't even bothering to make the sandwich. According to the Los Angeles Times, U.S. Attorney Bill Asaley, who oversees federal prosecutions in Southern California, has been pushing his office to bring cases that don't meet the DOJ's own standards for prosecution. 3 Justice Department officials say Asaley told a subordinate to ignore the federal government's justice manual, which explicitly instructs prosecutors to only bring charges they believe that they can prove at trial in order to prosecute protesters. Instead, Asaley allegedly demanded that prosecutors press on and secure indictments not based on evidence, but based on orders from Pam Bondi. That's not how the system is supposed to work. But the system can push back. Grand juries have reportedly refused to indict, skeptical of the thin evidence presented in these protest-related cases. Remember, grand juries nearly always indict. When they start saying no, it's a red flag that something is seriously off. And another sign that something is seriously off in the DOJ, court filings show that some prosecutors have refused to sign their names to contentious cases, forcing Asaley and his second-in-command to sign the pleadings themselves. So when your own prosecutors won't touch the case, maybe take the hint. The government's case against Obama would be even more challenging because Washington, D.C. juries tend to be more skeptical of government prosecutions. Add in the fact that many D.C. voters have been laid off or fired by Donald Trump, and Kamala Harris won 92.5% of the district's total vote in 2024. For all these reasons, I think it's pretty unlikely that a D.C. grand jury would ever indict Obama for treason. To actually indict President Obama, Ed with a law degree would probably need to find a district with jurors who are friendlier to Trump. But that would open up a whole other can of jurisdictional worms. It's not like Bondi can just run down to Florida and get a quick indictment against Obama because the alleged criminal acts happened in Washington, D.C. But let's say Ed and Pam actually manage to find a panel of grand jurors who think that it's likely that Obama committed treason, and they vote to indict. Then what? From there, the legal process unfolds much like it did with Trump's criminal cases. The indictment would be filed under seal, then the prosecutor would seek an arrest warrant or notify the former president to voluntarily appear in court. So once again, we would see the Secret Service detail flanking a former president as he walks into a courtroom. We might even get a mugshot. Obama would probably be wearing a tan suit. But by the rules of executive immunity that the Trump administration fought feverishly to protect and expand, Obama is immune to criminal prosecution for any actions he took while in office. At least, that's the theory of executive power that the Trump administration has been running with all year. Obama's legal team would promptly file a motion to dismiss, and the most powerful tool they've got is the same one Trump used to shield himself from criminal prosecution. As Devin explained last year, Special Counsel Jack Smith accused then former President Trump of conspiring with Justice Department officials to pressure states into overturning the 2020 election. But in Trump v. United States, the Supreme Court ruled that presidents are absolutely immune from prosecution for core constitutional acts and presumptively immune for official acts within the outer perimeter of their duties. The decision gave us a presidential immunity map. It starts with a president's core constitutional acts, which are given absolute immunity. These are things like pardons, commanding the military, and firing cabinet officials. These actions are clearly within the president's constitutional powers. The president also has presumptive immunity for acts within the outer perimeter of presidential duties. This is the fuzzier stuff, like communications with the Justice Department, meetings with advisors, and public speeches. Prosecutors can try to rebut this immunity, but the burden is entirely on them, and they can't use communications from the president or his inner circle. Finally, the president gets no immunity for unofficial acts. These are things like personal business, campaign activities, or criminal acts done outside the context of the presidency. Crucially, the Supreme Court also ruled that evidence from a president's internal communications, including testimony or private records from advisors, cannot be introduced at trial if it would reveal protected official conduct. This places a significant limit on what prosecutors can use in court. Although Justice Roberts said no president is above the law, the constraints placed on prosecutors by Trump v. United States makes prosecution of ex-presidents nearly impossible. So under this framework, any charges against Obama would almost certainly fail. Take Tulsi Gabbard's claims. She alleges Obama weaponized intelligence to launch a coup against Trump. But the 2016 Russian interference reports were produced by intelligence agencies and confirmed by a bipartisan Senate committee. Even if Obama shaped the messaging, national security is a core presidential duty, squarely within the immunity zone. She also accuses him of spying on Trump through the FBI's Crossfire Hurricane probe. As we've already explained, these kinds of national security decisions, whether good, bad, controversial, are likely well within the outer perimeter of presidential duties, meaning they're presumptively immune under Trump v. United States. The wildest claim? That Trump orchestrated a fake elector plot in 2016, an election Trump won. Straight out of the every accusation is a confession playbook. Even if Obama had pushed for alternative slates of electors or meddled in certification, what matters is the nature of his acts. Did he talk to his attorney general about it? Well, that's an official act. The court said such conversations are absolutely immune. That's why Trump couldn't be prosecuted for pressuring DOJ officials. And it's why Obama couldn't be prosecuted for supposedly talking to Eric Holder about helping Hillary Clinton. Even if Obama had gone rogue and, offered suitcases of cash to fake electors, prosecutors in the era of the Roberts Court would still face the same impossible burden, proving it was unofficial conduct without using internal communications or testimony from advisors. The bottom line is this: Trump v. United States built a legal fortress around the presidency. If it shields Trump, it should shield Obama too. Unless, of course, the Supreme Court decides immunity only runs in one direction. Even though Trump v. United States established sweeping immunity for a president's official acts, there is little to stop the court's Republican majority from carving out exceptions where it suits them, especially if the target is a Democratic ex-president. The court could narrow the ruling's application by declaring that certain acts fall outside the scope of official conduct. They could also label Obama's actions as personal, politically motivated, or otherwise not tied to core constitutional duties, even if they closely resemble Trump's immunized behavior. In other words, the same court that gave Trump a blank check could turn around and claim that Obama paid with counterfeit. I don't think that's going to happen, but I could have said the same thing about many of the court's decisions during Trump's second term, when SCOTUS has repeatedly made sweeping pro-Trump rulings on its shadow docket. With this court, apparently certain precedents only apply when your name is Donald Trump. As Obama put it in his official response to the allegations of treason levied against him, quote, "Out of respect for the office of the presidency, our office does not normally dignify the constant nonsense and misinformation flowing out of this White House with a response. But these claims are outrageous enough to merit one. These bizarre allegations are ridiculous and a weak attempt at distraction."
Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel: transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.